I welcome you all to this Constitution lecture series. For today's talk, we have chosen Article 368, that is the amendment provision provided in the Constitution. The literal reading of amendment provision states, Article 368(1), notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. Subclause 2. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill is passed in each House by the majority of total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. It shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill. It gives an exception, provided that if such amendment seeks to make any changes in Articles 54, 55, 73, 162, and 241, or either in Chapter 4 of Part 5 of the Constitution, Chapter 5 of Part 6 of the Constitution, and Chapter 1 of Part 9 of the, 11, Chapter 1 and Part 11 of the Constitution. Any of the lists in the 7th schedule, the representation of states in Parliament, and the provision of this article itself. The amendment shall also require to be ratified by the legislature of not less than 1/2, that is half of the states of the by resolution to that effect passed by the legislatures of the states before the bill making provision for such amendment is presented to the President for assent. Article provides for different modes of alterations of the provision of the Constitution. Article 368 provides 4 different modes that we can amend, 4 different procedures of amendment. First is a very large number of provisions are open to alteration by Union Parliament by a simple majority. Second, if a matter is not covered under articles to be amended under simple majority, for example, secession of a territory to a foreign power, that matter can be affected only by enacting an amendment act under Article 368. In cases of matter relating to federal structure of our Constitution, a special mode is prescribed. The bill for amendment must be passed by 2/3 majority of the members of each House present and voting. Such majority may be more than 50% of the total membership of the houses of each House, and then ratified by legislature of half of the states. The remaining provisions shall be liable to be amended by Parliament by a majority of 2/3 of the members of each House present and voting, and as same, such majority must exceed 50% of total membership of both Houses, and no ratification in this is required. No ratification by state legislature is required in this. It is much clear that the amending process prescribed by our Constitution has a distinct feature. As distinct features, the procedure for amendment must in some cases be classified as rigid, wherein it requires a special ordinance and special majority of 2/3, and in some cases it can be termed as a flexible, wherein a simple majority and ordinary procedure satisfies the amending process. Among these other general features of amending procedure given in Article 368 include, subject to Article 368, our Constitution vests constituent powers upon the ordinary legislature of the Union, that is the Parliament, and there is no separate body for amending the Constitution, as is provided in some different constitutions of the states around the world. State legislature cannot initiate a bill or proposal for amendment of the Constitution. The only mode of initiating a proposal for amendment is to introduce a bill in either houses of the Parliament, either Lok Sabha or Rajya Sabha. Subject to provisions of Article 368, Constitution amendment bills are to be passed by Parliament in same way as an ordinary bill. In other words, they may be initiated in either house and may be amended like other bills subject to the majority prescribed by Article 368. But for special majority prescribed, they must be passed by both houses, unlike like other any bill. No joint session for Constituent Assembly bill. If there is a disagreement between two houses regarding the passage of the bill, And Article 1081 provides for such joint session of the Parliament. Amendment bills, while as are governed by self-provisions of 368, are not required to follow Article 1081. The requirement of a special majority in both houses in Article 368(2) would have been negatory had the provision as to joint session been available in this sphere. The previous sanction of the President is not required for introduction in Parliament any bill for amendment of the Constitution. In case of an ordinary bill governed by Article 111, when the bill, after being passed by both houses of Parliament, is present to the President may either give his assent or withhold his assent. In such case, the bill cannot become an act if the President withholds his assent. But an amendment to Article 368 in 1971 has made it obligatory for the President to give his assent to the bill for amendment of the Constitution. The President's power of veto to veto a bill of amendment of the Constitution has been taken away by substituting the word shall give his assent in Clause 2 of Article 368 as it stands amended by 24th Amendment Act 1971. Well, this was an academic and procedural overview of Article 368 of our Constitution. A bit research further introduces us to the historical controversy among the legal fraternity as to whether an amendment of the Constitution made in manner provided by Article 368 must have to conform to the requirements of Article 13(2) clause as a law, as defined in Clause 3 of Article 13. Or in simple terms, whether a Constitution Amendment Act would be void if it seeks to take away or be inconsistent with fundamental rights enumerated in Part 3 of our Constitution. This question requires further study. Historically, our legal system, and by that I mean our apex court, Supreme Court, has been upholding the position that no part of our Constitution was unamendable. No part of our Constitution was unamendable. That Parliament might, by passing Amendment Act in compliance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. It was held that law under Article 13 subclause 2 referred to ordinary legislation made by Parliament as a legislative body, and would not include an amendment of the Constitution which was passed by the Parliament in its constituent powers. Such was the accepted legal position until Golaknath case in 1967. In Golaknath's case, a majority of 6 judges of a special bench of 11 overruled the previous decision and took the view that though there is no express exception from the ambit of Article 368, the fundamental rights included in Part 3 of our Constitution cannot, by their very nature, be subject to the provision process of amendment provided for in Article 368, and that if any of such rights is to be amended, a new Constituent Assembly must be convened for making a new constitution or radically changing it. After Golaknath's decision, Parliament superseded the decision by enacting a Constitutional 24th Amendment Act in 1971 by inserting Clause 4 in Article 13 and Clause 1 in Article 368, Subclause 1 in Article 368, and as a result of which an amendment of the Constitution passed in accordance with the procedure prescribed in Article 368 will not be a law within the meaning of Article 13. And the validity of the Constitution Amendment Act shall not be open to question on any ground before any court that the amendment takes away or affects a fundamental right. Even after the specific amendment, the controversy before Supreme Court did not cease because the validity of 24th Amendment Act itself was challenged before the Supreme Court in Keshavananda versus State of Kerala in 1973, which was heard by a full bench of 13 judges. The majority of the full court upheld the validity of the Amendment Act and overruled the case of Golaknath, the decision in Golaknath. The question thus settled in favor that a Constitution Amendment Act is not law within the meaning of Article 13 of the Constitution, and as a result, fundamental right in India can be amended by an act passed under Article 368 of the Constitution, and the validity of a Constitution Amendment Act cannot be questioned on the ground that the act invades or encroaches upon any fundamental rights. Thus, though the majority in Keshavananda's case has overturned the majority view in Golaknath's case that fundamental rights cannot be amended under Article 368 to fundamental rights can be amended under Article 368, but the majority in Keshavananda's case has affirmed a proposition asserted by the majority in Golaknath's case, and that be that there are certain basic features of the Constitution of India which cannot be altered in exercise of the power to amend it under Article 368. If, therefore, a Constitution Amendment Act seeks to alter the basic structure and basic framework of the Constitution, the court would be entitled to annul it on the grounds of ultra vires. Since the commencement of our Constitution on 26 January 1950, our Constitution has been amended 104 times till November 2020 in the manner prescribed under Article 368. But most significant amendment I would like to mention here is 42nd Amendment Act 1976, which alone would illustrate how momentous is the amending power under our Constitution and how easy it is to change extensive and vital provisions under the amending provisions without any elaborate formalities when the ruling party has a comfortable majority in both houses. 42nd Amendment Act was practically a revision of the Constitution to the extent that it introduced changes in the preamble and as many as 53 articles as well as 7th schedule. 42nd Amendment Act sought to change the vital principles underlying 1949 Constitution. Clauses 4 and 5 were inserted in Article 368 by Mrs. Gandhi government to control parts of Keshavananda's decision that though the fundamental rights constituted no limitations to the amending power, there were other implied limitations, that is, the power to amend could not be used to alter the basic feature. The Indira Gandhi's government sought to arrest these implications of Keshavananda and cut the fetters sought to be imposed on the sovereignty of the parliament as a constituent body, not as a legislative body, as a constituent body, by inserting two clauses to the Article 368, Clause 5 and Clause 4, where Clause 5 declared that there shall be no limitation on the constituent power of the parliament to amend the provisions of the Constitution, any provision of the Constitution. Clause 4 stated that at any rate the validity of no Constitution Amendment Act shall be called in question in any court on any ground. 42nd Amendment Act also included Article 51A on fundamental duties in order to counteract the sweep of fundamental rights, and it also devalued fundamental rights by expanding the scope of Article 31C to fundamental rights. The 42nd Amendment Act has in its turn been superseded by the Constitution Bench decision in Minvera Mills case in 1980, in which the bench adhered to the decision in Keshavananda that Supreme Court struck down Clause 4 and 5 as inserted in Article 368 by 42nd Amendment Act as violative of the basic features of the Constitution, that is judicial review. So far to present times, the decision in Keshavananda's case has been followed in subsequent cases by the Supreme Court, and as a result, Article 368 as so interpreted by the highest court of our country, Supreme Court, leads to the following propositions. First, any part of the Constitution may be amended after complying with the procedure laid down in Article 368. No referendum or reference to Constituent Assembly would be required to amend any provision of the Constitution. But no provision of the Constitution or any part thereof can be amended if it takes away or destroys any of the basic features or basic frameworks of the Constitution. Thus, apart from procedural limitations expressly laid down in Article 368, substantive limitations founded on the doctrine of a basic feature has been introduced in our Constitution by judicial innovation. The Supreme Court has refused to foreclose its list of basic features, and the Apex Court adds to this list as it deems fit from its subsequent cases. Honorable Supreme Court in 2007 case stated that all amendments to the Constitution made on or after 24th April 1973 shall be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21, read with Article 14 and Article 19, and the principle underlying that it shall be a matter of constitutional adjudication by examining the nature and extent of infraction of fundamental rights by statute sought to be constitutionally protected. And as such, the present position of applicability, usability of Article 368 is as so long as the decision in Keshavananda case is not overturned, if it be shown that any particular Constitutional Amendment Act does something more than to amend, that it would be ultra vires the power conferred by Article 368. And in that case, the court would be bound to strike it down, notwithstanding the exclusion clause. Our viewpoint on this is that after the reaffirmation of and extension of the applicability of the doctrine of basic feature, basic structure in the Minerva Mills case, it is now evident that so long as the decision in Keshavananda case is not overturned by another full bench of Supreme Court, which may come only as an extraordinary event, any amendment of the Constitution, if is liable to be interfered with the court on the ground that it affects one or other or any basic feature of the Constitution. The foregoing view of the majority in Keshavananda's case as to the basic feature in itself is debatable, inasmuch as there is no express limitation upon the amending power conferred in Article 368. If it is supposed that there are some implied limitations, it is difficult to appreciate how the court, after holding that the fundamental rights did not constitute such inviolable part of the Constitution, come to the conclusion that the judicial review, which is itself an adjunct of fundamental rights, could so be concerned. It would therefore be no wonder if another full bench of the Supreme Court comes to overturn this decision in future on following grounds, and I may present the grounds. That Article 368(1), as it stands amended in 1971, makes it clear that not only the procedure but also power to amend the Constitution is conferred by Article 368 itself and cannot be derived from somewhere else, such as Article 245. Hence, the limitation, if any, upon the amending power must be founded from Article 368 itself and not from any theory of limited, implied limitations. The word repeal in Article 368(1) also makes it clear that amendment under Article 368 includes a repeal of any of its provisions, including any supposed basic or essential provision or feature. That the Constitution of India makes no distinction between amendment and total revision, as do some constitutions of the world, like in Swiss Constitution. But our Constitution does not differentiate between amendment and total repeal. There is no bar to change the whole Constitution in exercise of the amending power, which is described as the constituent power under Article 368(1), and that accordingly it would not be necessary to convene a Constituent Assembly to revise the Constitution in toto. In Sansanka versus Union of India 1981, it was held that though subject to the procedure laid down in Article 368, the power to amend the Constitution is vested in Parliament. While exercising the power under Article 368, Parliament would not be subject to the limitations which curb its legislative power to make laws under Article 245, 246, because the amending powers conferred by Article 368 on Parliament are the constant powers. As a result of majority judgment, it is 7:6 in Keshavananda case, which has been followed by majority 4:1 in Minerva Mills case, a most intriguing legal tangle has emerged on the question whether the entire Constitution can be repealed by resorting to the procedure prescribed under Article 368. It should be noted that owing to divergence among the opinions of several judges, it is difficult to ascertain what is the opinion of the majority in 13-judge bench, with majority decision split between 7:6. But since the decision of Justice Khanna broke the tie between the rest of judges, it is through judgment of Justice Khanna that we must refer to explain for us the question put above. In Keshwananda's case, the majority held that though the Constitution itself does not exempt any of its provision from amendment from its amending power prescribed under Article 368, though Article 368 does not admit of any implied limitations on amending power, the meaning of the very word amend leads to the following limitations. While any piecemeal change may be made, the old constitution cannot be totally destroyed or so radically changed as to lose the identity. Hence, the basic structure or basic feature of the existing constitution cannot be amended through the power of amendment as provided in Article 368. Hence arises the legal question as to how. First, 1949 constitution may be replaced by an altogether new constitution if need arises and if need be. And second, if a basic feature such as a parliamentary system of government may be replaced by presidential system of government. What if such need arises, and what can be the remedy? Three modes have been suggested: revolution, parliament converting itself to constituent assembly, and referendum. As far as revolution is concerned, it is out of the province of constitutional law. Justice Khanna himself observed in his judgment that it was to avoid revolution that a provision for amendment is included in a written constitution of our country. Second, for the constitutional bench division in the Minvera Mills case, a constituent assembly could have been set up by amending Article 368 itself. But the majority in Minvera Mills case held that the limited nature of the amending power in Article 368 itself is one of the basic features of the Constitution, so that Parliament cannot enlarge its own power by making itself a new constituent assembly. Any such amendment of Article 368 or ordinary law made by Parliament would be unconstitutional according to Minvera Mills decision. Hence, before taking any step in this direction, the decision in Minvera Mills should be got rid of by submitting it to a review by another constitutional bench or by placing a specific question to a larger bench of more than 5 judges. As regards to referendum, however, the decision in Minvera Mills case would not stand in the way, inasmuch as a referendum to the verdict of people would not be enlargement of amending powers of the Parliament itself. In our opinion, thus, a referendum as a mode of amending the Constitution itself or abrogating its basic feature may be provided for by passing a constitutional amendment bill according to the provisions laid down in Article 368. I would like to end this lecture conversation by stating 2 personalities as they addressed the Constitutional Assembly. The nature of amending process envisaged by the makers of our Constitution can be best explained by referring to the observations made by Honorable Pandit Nehru under reconciliation of written constitution with parliamentary sovereignty, and I quote, that the Constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. And also in words of Dr. B.R. Ambedkar explaining the proposal for amendment introduced by him in Constituent Assembly, and I quote, those who are dissatisfied with the Constitution have only to obtain 2/3 majority, and if they cannot obtain even a 2/3 majority in the parliament based elected on adult franchise in their favor, their dissatisfaction with the Constitution cannot be deemed to be shared by the general public. In the end, I will sum up this lecture and a scope of this amendment section in a question. How does generations of citizens that are born years after the framing of the Constitution find their will and aspirations for the nation reflected in the sections and provisions of national Constitution? The whole power in our Constitution flows through we, the people, through the will of the citizens. And governments do not come into being by state papers. Governments are in fact the expression of the will of the people. Thank you.